Okay, I think we'll make a start. You're very welcome this morning. My name is Mark Spence, Managing Director of CEF, and I'm delighted to welcome you this morning to this webinar, second in our series of webinars with our legal patrons, Selig. And this morning, Kiera Lee, Partner and Head of Employment at Selig, is going to take us through some of the very salient issues in the post-COVID. Are we post-COVID? Are we still in COVID? There's a lot of issues out there, but there's actually a lot of general employment legislation and changes out there as well, which are very important to all our members. So here, I'm going to pass over to you. I'm going to invite members to submit their questions. We really do want you to submit questions and make this as interactive as possible. So if you use the Q&A button, which you'll see at the bottom of your screens, that will submit questions directly to Kiera and I, and we will pick those up at the end of the session and discuss those questions for you. So as I say, please do make use of that function. But with no more ado, Kiera, I'll hand over to you. Look forward to hearing what you have to say, and we'll pick questions at the end.
Thanks very much, Mark. I don't normally have too much bother making myself heard, but if there are any issues with sound, if I'm too quiet, if anyone wants to pop any comments in the Q&A or the chat box, I can turn up some volume. So thanks for joining us this morning. I am going to take a run through, although the talk is entitled Back to Work, I'm going to cover off some back to work information, absolutely. I'm not going to get too bogged down in COVID and furlough and things like that, because I think everybody's pretty au fait with it. But I also want to take, I suppose, a look ahead at what's coming down the road and things that we might need to turn our attention to now. As an employment lawyer and HR director in my own firm, I do know that it's a very, very busy time for employers and HR practitioners, and we are never stuck for things to talk about or plans to make. So hopefully this morning we'll give a bit of an overview and, as I say, a bit of a look forward. So just to ease us in gently on something we're all familiar with, I think it's worthwhile doing a quick update on furlough, just so everyone's aware. So it's going to change again from the 1st of July, that the reduction from 80% contribution by the government from 80% to 70%. So just so everyone's aware of that. Now the employee continues to receive 80% if they're on furlough, which means the employer has to cover at least that 10% gap if they're not topping up to 100%. So, you know, it is beginning to cost more money as of the 1st of July. And then for August and September, that will reduce again to 60%. And again, the employee will continue to get 80%, but the employer then must cover that gap, that 20% gap. So I know that this is triggering a lot of employers to take a look at whether or not they're going to continue with furlough. And it is triggering, unfortunately, some layoffs and redundancies and restructuring. So it's just something, I'm sure you're all aware of it, but just to recap on it. So flexible furlough still remains in place. You can still use that. And a reminder that if you are in the unfortunate position of having to dismiss employees, you cannot claim their notice pay during furlough. So you can't claim that back. So a notice pay is entirely at the cost of the employer. And a reminder again, if we're managing holiday pay and holidays being carried over, that holiday pay can be claimed both during full furlough and flexible furlough, but it must be topped up to 100% in order to ensure that the employee takes that holiday. Okay, so back to work. I put a question mark there because I know that a lot of people haven't stopped work, including me. But I suppose by back to work, we maybe mean coming back into premises or offices that haven't been used before, as restrictions hopefully continue to be lifted and relaxed. So just to cover off a few things that have changed and have been updated. So there is an update on shielding. Shielding is currently paused. I think we're probably all pretty familiar, but this is people who are clinically extremely vulnerable and who need to take more care. So a bit of contradiction in the government guidance. So they say shielding's paused. There's no requirement for people to shield any more than someone who isn't clinically extremely vulnerable. However, the government guidance does say, but we are still asking you to take care. So those employees are being asked, or people as well as employees are being asked to, try to avoid mixing in their own homes, stay outside, just continue to take a few more precautions. So if you have employees who say they're shielding and they can't come to work, that's not technically accurate, but the advice is still to allow them where possible to work from home, or maybe to add on a few additional safeguards for them if they are returning to the office. And they can no longer claim sick pay or employment support allowance as a result of shielding. But the government guidance does say that if there is still a requirement for someone not to come to work and they can't work from home, that an employer can agree to put them on furlough. Now, obviously, that will be subject from the 1st of July to those rules I've just covered there now, with the additional payment from the employer. So technically, we're told shielding's paused, but there is still a bit of a hangover from that, in terms of making sure vulnerable employees are looked at. One category that we do have to be very careful of is our pregnant workers. So pregnant workers were, again, a lot of debate around whether or not they didn't quite fall into the shielding, but whether or not we could ask them to come to work or insist that they remain away from work. So there was some guidance issued by public health to say that prior to 28 weeks, they don't consider pregnant workers to be any more at risk of getting COVID, or for there to be any particular risks to mother and baby before 28 weeks. And they would just be treated in the same way as other employees. But post 28 weeks, there is a heightened risk, and they're asking, where possible, that pregnant mothers do not come to work. Now, it will depend, and that they work from home if possible, but it will depend obviously on the industry, because we've always had this requirement, setting aside this updated guidance on the 28 weeks, to conduct a risk assessment for pregnant workers from day one, for workers who not only are pregnant but women of childbearing age, to ensure that there is no particular hazards or risks to them as a result of their working arrangements. So we do have to conduct a risk assessment, and if it is that we can't provide a safe space for pregnant workers, then they wouldn't be at work anyway. But that is now, I suppose, taken up a bar. Bar is raised from the 28 weeks. So it definitely gives employers something to think about. And again, if they can't come to work and we can't offer them an alternative and they can't work at home, they do have to be paid. Again, we think the guidance is not clear, but we think that we should be able to put those employees on furlough. But there is a change for them, different from people shielding. We probably do, and again, it's just not spelled out anywhere, but on balance, my view is you need to top up their salary to 100% of their wages. Now, if you are getting these employees to do alternative work, it needs to be of a similar nature to the work they do. Look, you can agree if the employees are happy to do admin work or something that they're not normally used to doing, there's no problem with that. But there definitely is a strong argument that you wouldn't necessarily be able to change their wages to reflect that. But no clear guidance, it's nothing set in statute to say that they have to be paid full wages, but always, and particularly in Northern Ireland, act with caution around pregnant workers. So risk assessments, then again, I think you'll be well aware that we are required to conduct risk assessments. Under the health and safety legislation, employers have the obligation to ensure a safe system and a safe place to work for employees. Just a reminder that employees also have an obligation, a statutory obligation, under the legislation to ensure that they assist their employers in this regard, and they have an obligation not only to themselves but their fellow employees not to cause any harm. So that's very useful when we're asking people to wear masks or take tests or things like that. You know, that there is this statutory requirement that they owe a duty of care to their fellow employees. So in terms of risk assessments, I suppose the main thing is, depending again on the work environment, whether it's indoor or outdoor, whether it's factory setting, manufacturing sort of setup, or a construction site, it does really depend on the setup. But if we're talking about office setup, we do have to remember that the guidance is still stay at home if we possibly can, and if not, you know, we have to allow on the return, we have to still keep to this 2 meter social distancing guidelines, and you know, where possible, we should be ensuring that takes place. And if it can't take place, then we have to put other things in place, barrier screens, PPE, that sort of thing. The usual rules around cleanliness and hand washing and cleaning things down and all that sort of things, all those sort of things apply. And a couple of additional requirements or things that maybe people haven't thought about that have been raised to me over the last number of months. It's been this requirement to have a first aider and a fire warden on site. So generally, although it isn't set in stone, that the recommendations are that for employees up to 50 employees, you would have one of those. But if you have a bigger building, you might need one per floor. So it again, it is very much depending on the setup. But now, of course, we're coming back and potentially in smaller bubbles, different groups, and we may not have the provision of health and safety or designated fire safety warden in those particular groups that are coming back in. So you might want to have a think about additional training, maybe getting a couple of additional people trained up so that you have a designated people at all times. That might not be practical. So some of the suggestions are that, you know, you conduct, and you can do it online, you know, you conduct some general training for everyone and make sure the basic requirements are covered. So in terms of first aid, the basic requirement is, you know, you have a first aid box that everyone knows where it is and everyone knows what your arrangements are in terms of first aid. So if there's an emergency, who do you ring? Where do you go? Who do you speak to? That sort of thing. And then for fire risk, you know, a general idea of, you know, the exits and when the fire drills will be, and any other arrangements that you have in place in case of an emergency, and why that responsibility would have lain with the fire wardens or fire marshals. You know, maybe a good idea for people coming back in to carry out a bit of induction, go through that training. If you are doing the training, getting them to read something, I would recommend you get it signed off and confirmation that it has been signed, that it has been read. And if you're doing it, you know, by a webinar or something like that, you know, a list of attendees, and make sure that you mop up any people who aren't able to make certain meetings, etc. So it is a bit of an important one, and if you're in a transition, maybe a bit more difficult to manage. And I would say it's managed by, you know, you could do those transitional arrangements of just keeping everyone up to date. Generally, risk assessments for return, as I say, will be very specific, but as well as risk assessing your building and any operations or I suppose processes that you might need to go through, you also need to risk assess any particular individuals who have additional concerns. So don't forget about you know, people who might have some additional health issues, and you might need to reach out to people and give plenty of time. If you're expecting people to come back, let them know your arrangements. Consultation communication is always key in these circumstances for making people feel comfortable about the return, and give the, you know, the opportunity for them to raise issues, and you can address those before they come back. So hopefully that will make any return a bit easier to take. working from home. So I, in particular, have had a lot of queries about employees who do not want to come back to the office. Now, it's very much a broad spectrum, but it seems to be those are the people causing the most concern, rather than people who are insisting on coming into the office or the workplace. It seems to be those who really have adjusted to being at home and like the flexibility that has given them, and I suppose most of us will have experienced, no commute now is nice, seeing the kids at lunchtime, nice most of the time, that sort of thing, being able to do drop-offs, walk the dog, whatever it is you might want to do. So people are asking, can I insist that people come back into work? So the answer here is that we're still in a wee bit of a grey area in terms of whether or not we are fully back to work, because we're being advised that still, if we can work from home, to work from home. But it is very much an assessment for the individual business as to whether or not they are ready to come back and they need people back. And in their industry, everybody's back and you want to move forward to getting people back. So if your business needs it, you're entitled to do it if you can do it safely and you do your risk assessments, etc. So there is no right for people to insist on staying at home, but I think if you have some recalcitrant employees at this stage, it is quite difficult to insist unless, because of the guidance, they could turn around and say, well, I've been working at home all this long time and it's working well. So you just have to consult with these employees and make them comfortable and find out why it is they don't want to come back and work on it that way. Now, if they're absolutely insistent that, they like work from home and that's where they want to be, you should be offering them the opportunity to make a flexible working request. So that request is open to not only to people with child caring or other caring obligations, but it's open to anyone. Anyone can ask for flexible working, and flexible working covers home working, reduced hours, compressed hours, and this blended working now, so working from home some days and not others. So it comes in all shapes and sizes now. And I do think that maybe this idea that we can't work from home, or the certain industries must be in the office or on site at all times, has definitely been eroded, and it's harder maybe for employers to say no, it doesn't work, whenever it has been working, at least to a certain extent, for the last year, coming on 15 months. So the flexible working request, if someone has 26 weeks continuous service, they've got the right to make the request. There are certain statutory time limits that you need to comply with around that. So make sure you know what those are. You normally have to, if you don't want to outright agree the request, you normally have to have a meeting with the employee, and there's a right to appeal there as well. But accommodations and compromises are allowed under the legislation if you can't grant what they're asking for. So they want 5 days at home, perfectly open to the parties to agree some form of compromise, and hopefully that keeps everybody happy. You can insert a trial period, or you can agree a trial period with the employee, and that might suit both parties. But if the party decides at a later date that they then don't want to work from home actually, or they want to change their arrangements, of course you can agree to make alternative arrangements, but under statute they're only entitled to make one flexible working request every 12 months. So you don't have to agree it, and if you have not much leeway or tolerance in terms of management hours for chopping and changing all the time, you don't have to agree it unless it suits you to do so, but be careful of creating precedents around that. So if you allow someone to chop and change, someone else wants to do that, you could be facing a complaint from the employee who hasn't been allowed to change back to what they're doing. So I think that is the main things on flexible working requests. But look, if anyone has any queries as we go along, absolutely jump in. And while I'm sharing my screen, I can't actually keep an eye on the questions, but I will mop them all up at the end. So one of the really big changes and challenges around employment in recent years has been this idea of employment status. So generally speaking, we have three main legal definitions or accepted legal sets of status: employee, worker, and self-employed. And the modern workplace now, definitely there is a bit of blurring of the lines, and we've had so much case law over the last 5 years around, right, who's an employee, who's a worker, who's self-employed. It's important for a number of reasons, one of them being that the tax status is different, which I'll come to. I'll have a look at the changes to the tax regulations on that. So who pays the tax? Very, very important. If you're the employer, obviously you pay the tax. If you're self-employed, you pay your own tax. So that's a big issue. But also an employee and worker are required to and entitled to be paid national minimum wage and holiday pay, which is the big thing, and I will chat a bit more about that. And so it's not an insignificant cost or consideration for an employer or a business as to whether or not someone is an employee or a worker. And obviously employees also have this right not to be unfairly dismissed that a worker doesn't have. So the distinction between these three sets of status are very important and have been the topic of much debate. I'm sure you're all aware of the Uber case, but just quickly. So Uber drivers were considered to be self-employed contractors by Uber, and potentially maybe not all of the Uber drivers, but some of them considered themselves to be self-employed. And there's been a long debate that has now reached the Supreme Court, so right from an employment tribunal upwards. And the decision of the Supreme Court now is that these drivers should be treated as workers. And again, the significance of that is that then they get national minimum wage and they get holiday pay. So that's potentially a big bill for Uber going forward and potentially going backwards. Now in GB, which we don't have here, they have a backstop on how far holiday pay can be back paid, and that is 2 years. So we don't have it here. Ours can potentially go back to 1998, which is why it's such a significant issue in Northern Ireland. And I'll chat in a minute about the PSNI case. But Uber have finally, they fought this the whole way. They appealed and appealed and appealed. And even initially after the Supreme Court decision, they said, well, that only really applies to us a bit because we don't run our business that way anymore. So actually it doesn't affect very many employers, but look, our employees, workers. But look, they quickly changed their tune, and in fact they now, even though they've never come out to formally say we accept that the drivers are workers, they have now amended their arrangements, and they do pay holiday pay and they do pay national minimum wage. So I think the battle has been won by the workers. So it's important for every industry, because if you have concern, have to get that right, otherwise it's pretty costly. And one of the big things that is not maybe as widely reported, unless you're really into reading judgments or take a lot of account of these updates in case law, is that the Supreme Court said, well, look, normally what we do, the first port of call in deciding whether or not the status of someone is the contractual relationship between the parties, and we go through the contract and what does the contract say and what do the parties agree. And the Supreme Court said, well, actually, in circumstances like this, where the relationship is an employment relationship, the employees, stroke workers, however they're described, are not, they don't have equal bargaining power, and they are potentially really disadvantaged by these contracts that these sneaky lawyers draft to say that they are not workers, that they're self-employed, or that they're not workers, or not employees and they're workers, whatever way the business have that drafted to suit their arrangements. But the Supreme Court say, we're not going to start with the contract of employment. It's not the right place to start. We will potentially take it into account, but where there's a real dispute or disparity between what the contract says and what the real arrangements are, we'll ignore the contract. So that is really big, I suppose, in legal circles, because for clients, we've always been saying, okay, well, how can we draft this? How can we minimize or change the language we use, or include certain clauses, or leave out certain clauses, and put in indemnities and all this sort of thing that says that this person is not an employee or not a worker. And now we've been told you can be as clever as you like around that. The court aren't going to be bound by that. The reality is what is going to be looked at. So the arrangements you have with your workers, contractors, employees, that's what we're going to look at. So we can't hide behind those contracts anymore. They're not totally irrelevant, but they really do need to match what is happening on the ground, and that's going to be the key, and always to keep an eye on them, because things do change. What initially started off as a very casual arrangement can change over time. So before I jump on to IR35, I'll just mention the Agnew case then. So Agnew and PSNI, it has made the news here, but surprisingly there hasn't been as much litigation as one might expect over something as significant. So this is the question over what should be included in holiday pay where employees don't get a set wage. So where it's variable, and there's inclusion of overtime or shift allowances or all sorts of production bonuses. I've seen a myriad of different things that employers use to remunerate and engage their employees. So the question is, which of these things should be included in holiday pay, and what's the right period of time for calculating holiday pay? The working time regulations, which is where we look to decide what happens on holiday pay, is it says that, and we've always done this, look back at the 12 weeks before, take the average wage and take it from there. But with such variable working and payment arrangements, and why it came up in the PSNI case in particular was they would say, well, look, around the 12th holidays, we do all this overtime, and if we take our holidays before that, that makes up a big part of our wages annually, and we don't get the benefit of that, because if we take our holidays in June, and you look back 12 weeks before that, that isn't included. So we think we are being significantly disadvantaged by that. So the tribunal said that this 3 months look back isn't enough. We think, we're not deciding on this, but maybe 12 months is more appropriate to look at in terms of overall. And then what should be included. So basically, there is quite a lot of case law on this, but it's around making sure that if it's a normal part of remuneration and it's regular enough, so one-offs don't count, and it's related to the work you do and it's intrinsically part of the performance, then it should be included. So they were saying that, over time generally should be included unless it's very irregular or one-off. And then the other big question was that this is I suppose quite a technical point, but if an employee is unhappy that they haven't been paid some wages, they make an unlawful deduction of wages claim, and they must do that within 3 months of the date the claim arises, or 3 months from the last in a series of deduction of claims. So there is a debate around what this deduction means and whether or not if somebody's paid holiday pay correctly once during the year when the 3 months runs from. So the Court of Appeal, the initial decision was that paying holiday pay once correctly during a year doesn't make up, and it doesn't break this chain of events, if you like, and people should still be able to go back if they haven't been paid properly for some time before this. They should be able to go back and include that in any claim. So potentially, if this 3 months doesn't apply and we can't break the chain of deductions by paying holiday pay correctly, then potentially holiday pay can be reclaimed back as far back as 1998 when the working time regulations came in. So that is why the figures bandied about in the press of 18 million and tens of millions of pounds that the PSNI could be facing this bill for is a major issue. So in GB, they have legislated to say that there's a backstop of 2 years that you can claim for. We don't have that legislation. And also they've now legislated to say that 12 months is the correct period of time. So the Supreme Court case on Agnew and PSNI has been heard, but we have not got a decision yet. We've been expecting it all last year, and now we're 6 months into 2021 and we still don't have it. I don't know whether the Supreme Court are hoping for some miracle that Stormont gets itself together and makes legislation so that they don't have to worry about it. But unfortunately, I can't see that happening. But I think it's the only answer, that there does need to be legislation on this, because the uncertainty is really difficult for employers, and some employers really could be facing a big bill. Not least the PSNI themselves. So it is a bit of what's the space for holiday pay, and if you don't have provision made for that, it's definitely something you need to look at. And if you have a lot of people that you have been treating as contractors and you're not sure whether they are actually contractors and that they might be due holiday pay, then you need to go about mitigating your risk and having a look at your arrangements around them. So let me just check on time, because I love to get talking about holiday pay and maybe get a bit too bogged down in it. So we move quickly on then to employee worker status in terms of tax then. So IR35, it's named after a circular that the Revenue sent, like a guidance note on how legislation should be applied. It actually comes from the ITIPA, the income tax legislation, but it isn't new legislation, it's just a change in emphasis, but it is very significant. So the idea behind it is that initially contractors were responsible for paying their own tax. They were considered to be self-employed, or if they were considered to be self-employed, and they paid their own tax. But what was happening was the Revenue were saying people aren't properly classifying themselves, and there are a lot of people who are in fact employed and they're considering themselves self-employed, and we are losing a lot of revenue as a result of this. So we're going to change the responsibility from people assessing themselves, their own status as to whether or not they're employed, to the end user, the client. And it's up to the client now for it's been in for public sector for a while, but now also for medium-sized companies to determine whether or not the services that they have been provided with have been provided by someone who's employed or self-employed. So that is very onerous and does change the emphasis and the onus on the end user to make the determination and then also to pay the tax in the end. So it doesn't apply to small companies, only to medium-sized companies. And in these circumstances, medium-sized company, you have to hit two of these three items here on the screen. So turnover of more than 10.2 million, balance sheet total of 5.1 million, and more than 50 employees. So any two of those three will make you a medium-sized company and will make you responsible for checking your arrangements. Where someone's providing personal services, you know, you have to determine whether or not they are truly self-employed. So it's described as a status determination. Now, there are some tools on HMRC and other large accountancy firms do provide this service as well, and they will determine whether or not someone's employed. I personally find it very amusing, if you like, that what takes a judge maybe a full day to decide can be done by filling in a box on HMRC, but they're willing to stand over these determinations as long as you have put in the information accurately. But it is really a judgment call as to whether or not someone is an employee, and it's pretty complicated because there are a lot of nuances, but the few main things that the tests that these tools use are the amount of control the person has over what they do, how they're integrated into the business or not, the mutuality of obligation test. So are they obliged to accept work? Are they obliged to turn up when you want them to turn up? And then the right of substitution. So those tools apparently take those into account. And look, they are very useful. And if HMRC are prepared to stand over them, then, you know, it should be okay. Now, there is a requirement to do this status determination from the outset. So as of April 2021, you know, everybody should have a status determination for somebody who provides personal services to them, either themselves or through this intermediary company, and keep a record of that somewhere. And also you should have in place a process for challenging the determination. So either if you know, if the worker / contractor wants to say that they are in fact purely self-employed, you would have to have a process of going through that. So very speedy run through IR35. Any questions? Happy to look at that. But you know, it really is a big change in emphasis and potentially, you know, quite an administrative burden, not to mention the additional tax burden of getting that right. So in place as of April this year, and I suppose we've got a bit of a stay of execution because it was supposed to come in last year. Don't know how quickly the revenue are going to crack down on it, but it is and has been one of their favourite complaints around tax evasion. So I do think that once they get over all those furlough calculations, that potentially will be their next hotbed of enforcement. Okay, so I have said many times to anybody who wants to listen that if COVID had not happened, the main thing we would be talking about in terms of employment is disability and our obligations towards disabled employees, both employing them in terms of recruitment, and then what we do when we get the employees into our organisation. It's very important to note that like anyone else in HR, I'm on forums all the time about attracting talent and the war on talent and engaging people and retaining talent and all these types of things. And the statistics for population growth are pretty scary. We in Northern Ireland, UK, have not yet started contracting in terms of that. So, but our growth is really, really small, and in decades to come, we just will not have enough people to do the jobs that we need done. Obviously, we've got issues around immigration, which I will quickly touch on, but we only apparently have two main untapped pools of workers, and one is disabled workers and the other is economically inactive females. So we have to either persuade ladies who've never worked back into the workplace, or people who've gone off to have children and never come back. So we've got work to do on that, and also we've got work to do on employing our disabled colleagues. And these are ready and waiting pools of workers. So we do have to know what we're doing when we employ these. Also, there has been a big policy shift from Stormont in terms of disability. I think we're going to see more legislation, and the Equality Commission, this is number one on their hit list, and they have been really pushing this agenda and are out there to enforce sanctions against employers who are just not getting this right, and it is a really tricky area. So let me just quickly run through it. And it will probably answer the question on COVID, long COVID, and whether or not it's a disability. So there are four main components for someone to be legally disabled. And the reason why that's important is because that's when all our obligations as employers kick in. So physical or mental impairment, which has a big substantial adverse effect, and it has to be long term, that's lasting or likely to last more than 12 months, on the employee's ability to carry out normal day-to-day activities. Now, there is some guidance in the legislation as what's meant by normal day-to-day activities, but generally common sense will kick in here. But it does include learning difficulties and ability to process information, ability to read screens. So it can be physical, but it can also be mental, and that is a very important distinction. So stress in itself is not a disability because it can be one-off, it can be temporary. But if someone has an ongoing issue with stress, which is causing other mental problems, and it can tick these boxes, so it's a mental impairment, it has a big impact on how they can do their work, it has lasted or is likely to last for more than 12 months, and it impacts them, then they can tick these boxes and they are disabled, and we are missing that a lot. So why is it important? Apart from attracting more people into the workforce, it's important because it's unlawful to discriminate against someone because they are disabled. And that's in terms of not, refusing to recruit, but also employers, as soon as we know someone's disabled, there is an obligation to make reasonable adjustments to allow them to carry out their role. So reasonable adjustments, and I've listed some here because they don't always jump out at people. It will depend. So reasonable really depends on all the circumstances. That's the size of the employer, was the physical arrangements of any workplace that someone comes to, the resources that they can throw at this, and any constraints of them, and also constraints of the employee. So the employee may not want to engage or agree to the reasonable adjustment that you have suggested for them. And I would say a good starting point is if you know someone is disabled, either they tell you at recruitment stage or they become disabled during the employment relationship, then you should really get a good assessment either from their GP, but more likely and probably more usefully from an occupational health expert, and they can assist in what might be a reasonable adjustment. You don't have to make these adjustments if it doesn't suit or it's too expensive or it just practically doesn't work for the business, but you really have an obligation to consider it, and if it is reasonable, to make it. So it all comes down to the reasonability. So some examples there on the screen, some pretty obvious, making adjustments to your premises. So is there a lift? Are there ramps? That sort of thing. But it may come down to, arranging for a job share or an alternative position, altering their hours of working, getting them more training. There sometimes can be an allowance for the amount of sick leave they get, or allowance for attending medical appointments related to their disability, providing other types of equipment. For instance, it says there a reader or interpreter. So I am no expert on learning disabilities or learning needs, but I know that you can get things for screens, you can get different type, and you can get also programs that allow things to be read out to people who have problems with processing information or reading from screens. So really, there is no one size fits all, and it's whatever works in circumstances. So if you fail to make those reasonable adjustments and the employee is not able to continue their work, then, not only could they consider themselves constructively dismissed, so you would have an unfair dismissal case in your hands, but you would also have this discrimination element. And the damages for discrimination are unlimited. So it is, not to mention reputational damage, which is very important also. So as I say, the Equality Commission are absolutely on top of this, and I think that we will see a real increase in disability claims. I'd already seen it happening prior to COVID. Other priorities have overtaken, but I was seeing a real increase in the number of cases. So it's something that I was discussing day and daily prior to COVID. So I think that we will return there again. And maybe it's an opportunity for businesses. Yes, there is additional compliance and there are things to look at, but I do think that there's an opportunity there to engage a valuable sector of the workforce. Okay, so let me just check. Yes, the only thing I haven't talked about is immigration, and I know that it was something on people's minds. So just an update on that. As of the 31st of December 2020, the right to freedom of movement of workers due to Brexit was taken away. Now, anyone who was resident here before the 31st of December, they were okay if they lived and worked here, and their family members also, but they were required to apply for settlement status. And then there was a transitional arrangement where they had up to the 30th of June. So as long as they were resident before the 31st of December, they have now until, next week. Is it next week? 30th of June to make an application for settled status. I would imagine anyone who needed to do so should already have done so by now. And if you're employing anyone who you believe may be subject to that, then you do need to conduct an audit. Now, you need to be careful about doing that because you don't want to single anybody out and potentially discriminatory to do that. So the advice is to make sure that you have up-to-date documentation for all your employees. In terms of right to work checks, if you go onto gov.uk, there's a list of documents that you can use that are acceptable. And for a while there, it was okay to conduct your checks online, and that was accepted. But gov.uk guidance now is that we are back to having to conduct those in person. So that temporary arrangement that was in place for COVID has now been lifted. So if you're checking documents, you do have to check them in person, make sure your passport's valid, etc. There was also a query over passports that were out of date because there was such a backlog and passports weren't being issued, I suppose due to demand. But the guidance on that hasn't changed. You were allowed to use an out-of-date passport within reason due to the backlog of getting new and updated passports. But I had a quick look and I haven't seen that that has run out yet. But I imagine that as they get on top of those passport applications, that leeway of using older passwords as relevant ID will also run out too. So keep an eye on that. So basically what happens now then, so if someone has applied for their settled status, that's fine, that stays, and they have the right to work here. But after 31 June, if either they don't apply for the settled status or you have somebody coming in to the country to work for you, you have to apply to be for a sponsorship license, first of all, as a business. And once you have your sponsorship license, then you have to have an individual application for each of those employees. And unfortunately, the opportunities to employ workers has become really limited under the new sponsorship licenses. So it really refers to, apart from a few exceptions, really refers to skilled workers. There's a minimum wage of 25,600 now. Again, there's a slight exception to that. You can go down to it's around 20,300, but you have to have also a number of points. So the employee has to be able to tick a lot of boxes and have a set number of points, so 70 points to be able to get in. And those points are, there's a point system, and again, the full guidance is on gov.uk, but you know, it really relates to skilled workers, people who have degrees, people with PhDs, and jobs at a certain level. So although the minimum is 25 grand, you also must pay the going rate, subject to that minimum, and there is a list of going rates again in the appendices on in the guidance on the gov.uk. So, you know, you can bring in people like architects and engineers and things like that, but you will have to go through that system and you have to pay the going rate for that. So happy to take any questions on that. Although the concept isn't complicated, there are quite a lot of rules to run through, and it's just a bit of a bit of an onerous process. But it's not difficult. It's just that there are a number of boxes that you have to make sure you're able to tick, and there's a lot of guidance. So it's a process that takes a long time. So if you are thinking of employing someone through this route or applying for this license, I would say leave yourself plenty of time to get through that. I'm not sure, no idea on numbers yet in terms of backlog or how many people are applying through this. And if you have, of course, if you already have a license, your current license will count. You don't have to apply for a new license unless it's run out. So you are still able to use that, but you'll have to use the new point system to bring anybody in under that. Okay, so the crystal ball, as I said, I want to take a quick look at what's coming up, and we are never short on things to discuss. A lot of this stuff is coming up or is being looked at this year in GB. We are not in a position where most of this has not come up in Northern Ireland. It's things that if ever our government turns its attention to updating its employment laws, these are the types of things that will be looked at. And I do think they will maybe come in by stealth because they'll happen in GB. They might creep their way into our case law, even if it's not our statute. So just a list of things there that people might be interested in knowing about. The National Insurance Contribution and Termination payments has already happened. So if you haven't been paying those, you need to make sure that you do that. The right to switch off has come in Ireland, how they're going to police that. So this is the right to log off your computer at a certain time of day, but we're not really sure how practically that's going to work. The Tupi case mentioned there is where one employee used to work across two businesses, and 85% in one and 15% in the other. And there was this argument about whether or not she should transfer to one new employee, or her work was split then post contracting, and there was an argument about whether or not she could transfer because all her employment didn't go to one employer. And the Govert's case said that, well, actually she could be employed by two different people. That's a real step away from what we have been advising on should be and where case law has been before, and it is very significant for people who tender for work. So it's something to keep an eye on. Those other things probably pretty self-evident, and I want to leave some time for questions. So I will take off my notes, and if anybody's got any questions, if they want to jump in. So Mark, have you had a chance to look there?
Yeah, I feel we haven't done you justice. Trying to get through all of that in an hour, fantastic. Well done you, but I'm sure we'll have you back again. We have a number of questions. First one, and it's probably the big one to do with the COVID scenario, is the advice to work from home likely to change anytime soon?
Well, it's probably a political question more than an employment question, but if we're following what's happening in GB, I think it will happen soon. We don't know, and obviously we have no one to at the minute to make these decisions or make these updates. So we could be hindered by what's happening on the Hill. But I do think it will happen. And I think even if there is no announcement on it, creep is already happening, and people are going back, and people will start to make their own arrangements because it's guidance, it's not the law. And of course we want to do the right thing and follow the guidance, but I think in the absence of very clear guidance, you will see more and more creep and people doing what they feel they need to do for their own businesses, and that's basically the bottom line, and that's what people will do.
Thanks for that. Is there an obligation on the employer to check an existing employee has been granted settled status? Is that an obligation?
Yes. So in terms of the right to work, an employer, whether they think they have anyone in their organisation or not, you are required to check every single employee's right to work and to keep up-to-date documents on that. So if that's not something you currently do, you should get to it and keep good records, and then regularly update that. So the onus falls on the employer, as do, unfortunately, the pretty significant fines if you get it wrong. So the answer to that very much is yes.
I just wanted to ask as well, flexible working is obviously going to be a big item on everybody's agenda going forward, and there was a report came out just yesterday from Build UK, which is the umbrella organisation for trade bodies like ourselves, and they did a pilot study for construction sites to show that flexible working could work. It's a difficult thing to implement. It could be considered a risky thing to implement. Would you have any advice at the moment for SME size businesses in Northern Ireland? I'm not talking about the BAMs and the Skanskas and so on. For typical Northern Ireland businesses, how would you approach flexible working with your workforce?
Yeah, I appreciate that flexible working arrangements does really mean additional management time, and yes, there is some technology, but it isn't accessible from a resource point of view for everybody, and for SMEs, that it really does come down to those managers and HR. In order to get those systems right and make sure you're covered both from a health and safety point of view, and also from just practically making sure that you've got somebody on site doing the job when you need it to be done. I don't have any magic formula, unfortunately, for that. But I do know that there's some, I suppose, basic bits of technology that you can use. Most HR systems now will allow you to do rotas and be able to check in, and people can access that, and they can access it via an app. And those are available at not much expense for smaller employers. And it is worth it for anybody, even if you have 10 or 20 employees. The license fees and those are not massive, and you definitely can keep an eye on that, and everybody can keep an eye on when they're supposed to be in and when the crossover is, and where the gaps are. So there is some technology out there. The better stuff probably is expensive and for bigger employers, but no, unfortunately the burden will still fall on the managers to organise that.
As ever, part of the speech. We're just going to take one more question here, just mindful of the time. So the final question that's come in, what do we think will happen with regards to employers checking the vaccination status of employees? We're aware that might be an ask in the healthcare industry. Is it likely to go wider than that?
Yeah, I doubt it. I think it'll be very controversial, even in the care sector and in the NHS. I can totally see the justification for it, and ideally we would, it seems to be sensible, but I don't think it will be subject to challenge. I've absolutely no doubt. And in Northern Ireland, we are particularly litigious, and I can see it being challenged on the human rights front. So where we are for now, a lot of employers really would like to see their employees be vaccinated and double vaccinated before they come back to work. There is evidence that we definitely get less sick if we're vaccinated, double vaccinated, and a lot of growing evidence that it really does prevent the spread. So difficult, tricky to ask most people are prepared to share the information. If someone is not prepared to share the information, I do think that you can insist on knowing so that you can manage the risks. So from that point of view, I think as an employer, you have the obligation to manage risks, and I think you can get around it that way. It is medical information, so it is sensitive data, has to be treated that way, and should be, those sort of conversations should be dealt with in confidence. We cannot insist on somebody getting the vaccine, but again, by counselling and consultation, maybe try to figure out why this person maybe doesn't want to get the vaccine, and whether or not there's anything you can do to manage the fact that they don't have the vaccine. But again, confidentiality will be key. We can't have somebody who, you know, being, I suppose, singled out in a way because they don't have the vaccine. So there are potentially ways around it, but we can't insist. And I know that it is going to be a thing. But at the minute, we're still in the situation where people are still getting vaccines, and we don't really know where that will, you know, the figures haven't quite crystallized yet to say I'm not getting it, I'm getting it, you know. So I think it's just a matter of managing it on a case-by-case basis.
That's great. Thanks, Kiera. Let's say that's all the questions we're going to take. We have recorded the session. We will share the session with people who've registered and applied. And we thank everybody for participating. Just to say, coming up from Selig in the coming months, we'll have sessions on director duties, project funding, accidents at work, succession planning, and many more. So again, we're very grateful to Selig for providing all of this information. Kiera, thank you so much for the effort you put in preparing for this morning. You've given us a huge amount to think about. I think we'll be back to you.
Yes, no problem at all. And thanks everyone for coming. And just to say that, Mark, if anyone wants to follow up, my details are on the slide, or if they want to go through you, that's fine. If there are any more questions, happy to address those. Thanks a lot, everyone.
Thank you, everybody, for joining. Thank you.
Thank you. Bye-bye.